Members, ladies and gentlemen, my name is Michael P. Marek, and it being for 7 o'clock in the evening, I am calling the regular meeting of the Zoning Board of Appeals of the Town of Orleans to order. Present besides myself are regular members, William McCarthy and Beth McCartney, associate members Peter Jablin and Bruce Taub, all of whom constitute a quorum. Also with us are the board secretary, Sandy Stewart, and the building commissioner of the Town of Orleans, Tom Evers. The first item of housekeeping is the approval of the minutes of the meeting of March 16, 2016, which was the last regular meeting of the Zoning Board of Appeals. The minutes have been circulated for review by the members of the board, and I'm asking whether there is a motion to approve the minutes of the March 16, 2016 meeting.
So made.
Is there any discussion on the motion? All those in favor?
Aye.
And opposed? There are 3 items on the agenda, and I'm asking first whether everyone necessary for presentation is present. The first is case number 2002-7, the application of Ralph H. Arabian for a variance concerning 97 Rock Harbor Road. Is everyone here?
Yes.
And case number 2002-8, that's an application of Gene and Randy Raymond. Their property is located at 106 Tarkiln Road. Is everyone ready to present that? And is there any opposition to that application? Third item is the application of Daniel and Leona Bicker. The property is located, this is for a special permit, and the property is located at 311 Tonsett Road. Is everyone ready to proceed?
Yes.
Is there opposition to that application?
I'm not sure if it's opposition, but I wanted to have an amendment to the building that's on the property. Okay, I wanted it pushed back closer to her house, away from my property.
Okay,
Okay.
then then you'll have a chance to speak
Okay.
to your as is necessary when the application is received. I think we'll take them in order. Case number 2027, the application of Ralph H. Arabian.
May I ask a procedural question first?
Yes.
If I'm not mistaken, this was a matter that was heard by the board within the past 3 months or 90
Yes.
days.
Yes.
And in my experience, we've not had a redo or a reapplication. And I wondered if there was any guidance in any of the statutes, rules, bylaws, et cetera, relative to the issue of the timeliness of reapplication.
There isn't any guidance on that question. However, the board did vote to allow that application to be withdrawn without prejudice. Mr. Arabian's coming back in, as far as I'm ruling, that he has every right to do that, and it's a brand-new application, as if the board had never heard any other application in 2015 or at any time.
And just for my clarification, there was a decision, there was, at one point in time, if I recall, there was a decision. The applicant moved for a constructive grant. There was an appeal by the board.
Yes?
And then following the filing of the appeal, it was at that time that the applicant asked to withdraw.
Yes. Yes, this was in January.
And it's your view, at least, that at any time, had that gone to court and not reached a decisional stage, and the applicant said, I'm going to pull it here, we would have had the authority, if you will, to say you can present it de novo.
That's right. In the scheme of a lot of different considerations, the application was withdrawn without prejudice with the approval of the court. Well, not the court. With the approval
Well, we
of,
think of you as the court.
I didn't mean to consider it that way, but with the approval of the board. So it's
And was
as
that
if-
informal meeting? Because I wasn't at that meeting, clearly.
It's as if it now, tonight.
Is here
it's
for the
as
first time.
Brand new.
Okay, understood.
And I'm presuming that without, I've eliminated as much as possible the elephant from the corner of the room. As far as I'm concerned, Mr. Larier, on behalf of Mr. Arabian, is speaking brand new, and I don't know anything about what he's going to say that may be the same or different from what he said before. I'm listening carefully, and I think we all have the obligation to do that, and that's my ruling.
That's fine. I
That's
also
all
have one other procedural question.
Yes.
There were some materials distributed to the board prior to the meeting.
Yes.
I'd never seen that as a practice before, and I had some concerns about the propriety of such action and wanted to raise that as an
Very
open
well.
question.
Mr. T-
As
Mr.
did I,
Mr.
Mr. Chairman.
Mr. Todd, if you're referring to letters commenting upon the application,
No, I believe that the applicant's attorney
Oh.
advocated on behalf of the application in correspondence that was distributed to all the board members.
well, it's going to become part of the file, and you did so immediately for public inspection. I think that we can accept that. It's not evidence, but it's considered to be part of the argument as a supplement to the application. For example, the application sets forth with some particularity the supports for the 3 reasons why the petitioner claims that he's entitled to a variance. In this argument or supplement is in addition to or as further support to the application.
Yes,
Is that a fair way of putting it?
yes, thank you.
So I'm just asking for precedential purposes. Are you saying that any application that's received, the applicant is not engaged in anything that we would frown upon if they lobby the board in advance of the hearing?
Well, I'm going to ask that question, whether there's been any communication with Mr. Arabian or any of his agents.
Well, the answer to that is that there has been memoranda distributed, if nothing else.
That's fine, but that's submitted in connection, it becomes part of the file. As long as there's been no discussion upon it amongst the members of the board or any communication by by the applicant or any of the applicant's agents to members of the board, then I consider that to
So you would distinguish between,
it's a help to the board, Mr. Tarbell, and that's to be welcomed. We can decide right now, and then you can decide to the weight to which you wish to attach to that. It's hardly even, it's evidential, it's argumentative, but it is somewhat helpful.
Mr. Chairman, for the
Yes,
record,
yes.
I'd like to go on record as saying that there was communication, email communication that I initiated to, in reply to this, this argument that was submitted by email, noting that without commenting on the application or on the substance of the attachment, that I did feel, as I think this spirit of Mr. Bruce's argument, that it struck me as being inappropriate and that the case had not formally come before the board. And maybe it's something we can take up in a, informal session about for the future, but when someone comes in and said with a revised plan, for instance, or some supplemental, once they're here to appear before us, I think that's entirely helpful, to use your word. I do just have concerns in general about the potential impact of things like this when they come in before the matter's been before us.
There was no way to refuse it, Mr. McCarthy, Mr. Top. It came in. Now what? How would you suggest that it would have been handled? Or what kind of ruling are you asking for?
I didn't take it that far.
Maybe I'm just,
I mean, I'm trying.
I'm just trying, as I said, I had not encountered such a situation before. And one could imagine that, and again, I may be over judicializing this, but if there were any opposition, and the opposition looked at the formal application, but did not have benefit of this extra application advocacy, it would be hard to deny that they weren't in some way prejudiced.
I suppose. I think if I represented the applicant, I would have done the same thing if I were, at least if I were concerned that the board of whatever nature, or in this case a zoning board, needed a little bit of help or education in connection with the issues. I would have submitted it in advance myself.
Mr.
if I may,
Chairman,
pardon, if I may, Mr. Chairman, that the problem though is that it is arguably a subjective submission as opposed to an objective one, and therefore I think the prospective harm that Bruce is referring to, my thought would perhaps be that as letters from abutters or other interested parties come in during the case of things, that it comes to Sandy and is presented in the file for the case for being brought up, and or for counsel of the applicant to present at the hearing. It's just the notion of beforehand that left me a little feeling a little awkward about it. That's
Mr. Chairman, Chapter 197 says that the board will accept supplemental materials up to 1 week before the hearing.
By chapter 197, those are the rules and regulations. That's out of the town bylaws,
There's ZBA.
the ZBA rules.
as part of the application.
Okay.
Okay, fair enough.
Mr. Lariah, how do you weigh in on this?
I'd like to ask if we could continue this till your next meeting, when there's a full complement of the regular members, if that would be okay.
I have no objection to that. But
I
will
do.
this time,
I do.
well, no, we'll have a discussion on
Yeah.
it. If the, all right, then you're moving for a continuance till,
Is it 2 weeks from today?
right now, the next regularly scheduled meeting would be March 16th. Not
April.
March 16th. April,
20?
Well, 27,
Today's the 6th, right?
so 14.
Yes.
today's the 6th.
Chairman, I question whether that's a valid basis to request continuance, that we have a full complement of voting members. The alternate members are indeed
Well-
served for the purpose, and this is
well-
a de novo case, as you
No,
mentioned.
first let's get the date, and then we'll ask the applicant for the reasoning, and then we'll talk about it.
Okay.
All I'm thinking in the back of my mind is if we do that after the board votes, then we'll just memorialize it in writing, Mr. Laura.
I think so. I was going to suggest it myself.
April 20th would be the next regular member.
No, I know of no reason
All right.
why we're entitled to that. It's just a request.
Well, it's going to be helpful to, let me ask this question. Is there anyone here in the hearing room having been given notice formally or informally by mail or otherwise, who is in opposition to the application of Ralph H. Arabian. There's no response. Is there anyone present who objects to a continuation of the hearing until April 20th, 2016,
Other than board members?
other than board members? And there's no one objecting to the continuance.
So are you saying the first? I could do that.
I can't make the meeting on the 20th. So we're just wondering what your next meeting is. And we are aware that you're going to decide whether we get any continuance or not, but
Yeah. I think it'd be the first Wednesday in May.
First Wednesday in May.
Fourth.
All right? Well, I'll ask again, is there anyone present who would object to the continuation of Mr. Arabian's application for a variance hearing till May 4th, 2016? No one present in the room. Members of the board, what is your pleasure?
Yes, Mr. Chairman, we're under
All right.
hearing here.
May 4th is the date you're asking for to commence the hearing?
I think so. Is that okay? Yeah, May 4th, thank you.
Very well. Members of the board, we have a request by counsel for Ralph Arabian to continue the hearing and have it start on May 4th, 2016. I have no objection to it at all myself. Mr. Todd?
At the risk of being too candid, it feels like forum shopping. And
If I
if
may-
you recall, no, this is a discussion amongst the board, and I'd like the chairman to rule that it's a discussion amongst the board only, unless people are recognized.
I think that's what we'll do.
So, if I may, in my view, I have seen nothing in this application that deviates from the prior application. There may be other arguments, but I've seen nothing in the application that deviates. The panel that will decide is at the chairman's discretion relative to whether it's the same panel, a different panel, blah, 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 blah. I note, incidentally, that in the last vote, which went down 3-2, I believe, that the two favorable voters don't happen to be in the room. And
No,
I
it's not-
can't
I was
help
not
but
present.
wonder if that influences this apparently last-minute decision. And I kind of, again, at the risk of being too candid, it just doesn't,
if I might,
no, we said no, and it should be
If I
no.
And Mr. Chairman, just for the record, I was not a party to either of the first or the continued hearings in that case, and I come to this with a de novo first impression perspective. Have spent a fair amount of time engaging in reviewing the matter, as I'm sure our colleagues have, and we have the quorum to hear it, and I have no conclusion to draw on this until the end of this public hearing, and I just, we are, as volunteers for this community, we're here, taking our time, and I think that there's no reason why this matter, there's no material reason why this matter should not be heard tonight.
Very well. Let the record reflect that Mr. Jablin and I were present at the earlier hearings. Mr. Jablin did not vote, and I did. I can state myself that I don't remember very much about the substance of the hearing. I know that all members gave attention to it, and I intend to give brand-new attention to this application.
Mr. Taub doesn't.
I don't I don't presume for a second that the evidence is going to be identical to what it was before. And it never is. Beth, what do you think?
I feel like it's forum shopping.
I think it gives the applicant an opportunity to get as many people as possible to hear the,
Only 5 people vote.
understood.
Isn't this a discussion period, or am I not hearing?
Mr. Taub has pretty much indicated he's already made up his mind, and that it's
Well, I
not a new
object to
vote.
that, sir.
no, no,
Mr.
no.
Marnick, I ask,
You can object, but
No, no,
you
I asked
said-
that-
do object, sir.
Understood.
This is a discussion amongst the board members, and you can't even show the board enough respect to hold your tongue until you're recognized.
We'll inquire a little further as to the impartiality of the members. Well, let's put it this way. Has any member of the board present this evening had any communication with the applicant or any of the applicant's agents which would need to be disclosed under the general laws? There's no positive response. Is any member of the board aware of any bias or prejudice in favor of or against the applicant? No positive response. I rule, therefore, that the members of the board present in this application this evening are indifferent and impartial. Now, on the request of the applicant for a continuance of the hearing till May 4th, 2016, let's poll. Is there any further discussion on that on that motion or request?
I also have a feeling that it is forum shopping.
Having that feeling, would that make you less than impartial?
No, I'm willing to listen. De novo, as they say.
Mr. Taub?
Could I request that when our discussion is complete, prior to the taking of any formal vote, that the applicant be given the opportunity to address the board again?
Very well. Mr. Taub, and
On the point of,
On anything they want.
of course.
They've heard the discussion,
right,
they've heard the arguments. If they wish to comment on it without interrupting the process, I welcome hearing their comments.
Mr. Taub, you've objected to the request for a continuance.
I have not, sir. I have inquired about it.
Very well. Are you aware of any fact or circumstance which would prevent you from being fair and impartial in deciding this
I
application?
do not know of any such fact.
Very well. Then, before voting, is there anything else that you would like to speak to, Mr. Laraya?
No, we were just asking permission for the extension.
Very well.
I would just like to add that it seems...
identify yourself for the record.
I'm sorry, I'm Tim Brady from East Cape Engineering. I prepared the plan. I've been to boards for many years, haven't been in this business for about 30 years, and typically, all boards have allowed applicants to continue hearings, particularly before the hearing has even opened, for the purposes of giving the applicant the ability to have as many people as possible review an application. As we all know, we're going to try and treat this as a new hearing. Obviously, there's history, there is a decision that's been made in the past, and to deny the applicant the full benefit of a board for no particular reason other than moving forward tonight, to me, just doesn't seem to be fair to the applicant. That's all I'll say.
Having served on now 3 different zoning boards of 3 different communities, I respectfully have to disagree with the generalization that you just suggested. But when there's a reason for a continuance or rescheduling, that's a different story.
Then I'll ask for a vote on the request to continue the hearing until May 4th, 2016. Mr. Taub?
I vote in favor of granting it.
Mr. Joblin,
Not in favor of granting it.
Mr. McCarthy,
Not in favor.
Mr. McCartney,
Not in favor?
and I vote in favor. The request is denied, 3 votes to 2. We will proceed. All members present will consider. We have a quorum.
Good evening again. My name is Dick Laraya. I'm an attorney with the law firm Lorine Canega in Orleans Center, and this is 97 Rock Harbor Road. I just want to summarize a couple of things and then look at the application. This property is about 2¼ acres, and prior to the year 2014, with the definition of buildable upland as it existed at that time, this property had about 90,000 square feet of buildable upland. After 2014, with the new federal insurance, flood insurance rate map, the 90,000 became 35,810 square feet of buildable upland. So with just that one change, almost 55,000 square feet of buildable upland was lost. I'd like to go to the application. We answered the question, present use of the land. There's one lot with one single-family house and one garage. And what the applicant would like to do is take that one lot, make 2 lots, subdivide it into 2 lots, so that there could be a single-family house and a garage on each lot. This is a petition for 2 variances because each resulting lot will have less than 40,000 square feet of buildable upland, using the definition in the bylaw and using the 2014 flood insurance rate map. So the land will be divided into 2 new lots, is the request, each with less than 40,000 square feet of buildable upland. Let's take